Now, we had a couple of votes on the Supreme Court, I forget which case it was, for the proposition that you should either try people or release them. Those were the two positions.
Mm-hmm. But one of the problems is
valid,
where to try them. Let's
talk about that.
So it turns out to be very controversial to say, well, federal court in Manhattan, for example.
What's so controversial? They know how to prosecute cases there.
They have done, but this time there was a firestorm of protest when the Obama administration suggested that's where they were going to try people.
And perhaps that was somewhat realistic. I mean, keeping everyone involved safe during that process maybe it would be a major undertaking with all this publicity in a place like New York City. I saw an article written by a retired federal judge who advocated that the federal district court applicable to this would probably be the D.C. district, could assign judges to go to Guantanamo and hold their trials right there. Mm-hmm. And you know, in these items like the habeas cases, we don't have a right to a jury trial, so it's a judge deciding everything, and somehow that seemed like a rather practical solution to me, to get the show on the road and get these charges filed and sorted out.
Would it be constitutional to conduct a criminal trial in Guantanamo without a civilian criminal trial in Guantanamo without a jury? See a problem there?
A civilian?
A federal criminal trial. Just bring your charges under the Federal Criminal Code, Title 18, and Congress can create some kind of branch office, a Guantanamo division of the Southern District of New York or whatever, and have a proper federal trial. What's wrong with that?
You've been teaching at Yale too long. These are extreme hypotheticals.
It's a thought experiment. It's a thought experiment.
Well, without answering that right away, we could come back to it. One of the important things in that Supreme Court decision in 2008 was to say it may be the case, and we don't have to go there, as to whether Cuba really has sovereignty or whether the U.S. has sovereignty. And the U.S. really was trying to be too clever by half in saying Guantanamo, well, that's not really ours, and so there's no jurisdiction. What the court said was, let's look at it de jure, by law. We don't have to resolve that. De facto, we do have authority over Guantanamo, which clearly is right.
We've been there for 100 years.
Would that the court did that in some other situations where they've tried to draw a bright line between de jure and de facto in segregation cases, for example. But anyway, it was interesting and important that they said, realistically, it's been ours, we control it, so the American Constitution applies.
But
because the American Constitution applies, thinking a little about your hypothetical, you couldn't do what you're suggesting.
Because why?
Because the American Constitution says you got a right to a jury trial for a federal
fly
trial.
Jurors down. Why not do that? We fly.
You said without jurors.
Well,
if you fly jurors down,
I'll change the hypothetical then.
If you fly jurors down, you could do it if they're the right jurors. They have to come from someplace, and that gets to be very tricky as to
it does.
Who are your peers.
There's another dimension to this, by the way, in terms of where you want to have the trial and what kind of trial you want to have. Current thinking, and this is a change over the last, say, 30 years, has been to respect ever more the interests of victims in the criminal justice process. So one thing about having a trial in Guantanamo, I've been there. Have you been? You must have been there at some point.
I've been there 9 times.
You've been there a lot then.
I have not, blessedly.
As a lawyer.
Hope springs eternal.
However, I've been there another couple times as a
naval officer. Yeah. But how are the families of the people who lost their lives on 9/11 supposed to get to Guantanamo? It's really hard to get there. I mean, you could bring them down. I think some of them may have been brought down. But if you put Khalid Sheikh Mohammed on trial in Guantanamo, regardless of what kind of forum you have, whether it's a military commission or a U.S. district court of some kind, or some entirely new forum, it's going to be burdensome. And you could do closed circuit television, I suppose. In this day and age, Cisco will sell you a program for a few $1,000s, and you'll be able to have.
Well, you're certainly right.
Television.
That victims' rights has become much more important in the context of criminal cases, and the right of the victim's family to talk about what the loss was. I'm not sure that rises to the level of a constitutional challenge if they were excluded. And my guess is it would not. That's a different matter from whether it would be good policy to have.
Right, or what Congress would do.
Yeah.
Right.
But there again, you're talking in terms of 9/11, which perhaps is a good thing to talk about with the Sheikh. But the vast majority of these other people have nothing at all. Nobody even hints at them being involved in 9/11. They have nothing to do with 9/11.
Right.
They were in the wrong place at the wrong time.
My client was living in Pakistan at that point in time. And in our habeas decision, Judge Robertson basically held that there was really no convincing evidence and my client ever did anything adverse to the United States or any of its allies as far as taking up arms or that kind of thing. So I think the big problem is to search for a solution as to how this vast number of people, the 90%, if you will, should be tried or reviewed and hopefully set free.
Well, that makes me think of the title of that rock song, "Looking for Love in All the Wrong Places." Where are we supposed to look for? Sorry, Avi. I'll explain the reference some other time. Where are we supposed to look? Are we supposed to look to Congress for that, or the courts? Have the courts done all they can do?
Well, I don't think the U.S. Supreme Court has really enunciated any rules as to who should be confined and who should not be. I mean, all of that law is being developed in the D.C. Circuit.
Good thing, bad thing?
Well, I think a bad thing. I don't think that the D.C. Circuit, as presently constituted, is really, they haven't shown too much aloha for our clients.
Avi, suppose you were advising people that had a horse in this race. Would you tell them to go up to the Hill and see what you could get out of Congress? Or would you tell them avoid the Hill at all costs and take your chances with the federal judges?
This week or in early January?
Well, would it make a difference?
Of course it would make a difference.
But would it yeah, it'll get worse, I suppose,
Right.
after New Year's. But
Right.
talk me through that. Talk me down from the proposition that Congress, which has the authority to define and punish offenses against the law of nations, that's the part of the forest that we're in here, shouldn't be looked to for a solution.
Well, a couple of different levels. One is that because we're talking about some basic human rights and perhaps universal, recognized by conventions and treaties and so
Right.
on, we're talking about something pretty basic. We're also talking about something basic in constitutional law terms. Fortunately, we don't put those things to a vote in a case-by-case way because sometimes, undoubtedly, the Congress would be influenced by the kind of argument that Scalia made in dissent, which is it is almost certain that American lives will be lost because of this decision. Well, once you say that, it's pretty hard for a representative from wherever to say, well, that's okay with me because there's a principle here. And that certainly would be said. So I think we look to the courts and to the lawyers and to procedures to avoid or to stand up against demagoguery. Congress, on the other hand, does have a lot of authority in this area. So then you say, well, what are they likely to do before you put something in front of them?
Yeah, it's a very interesting challenge, I think, to a responsible citizen. It's clear that Congress has a constitutionally based source of authority.
Mm-hmm.
Congress is the body that's supposed to make the law. Congress could elect to depart from international norms, for example. The last in time governs. If you have a statute that comes after a prior inconsistent treaty, it's the statute that governs. And yet, the congressional record is so filled with, let's say, odd events and examples, really examples that are worthy of the Bishop Museum for strange approaches to these problems, that you really would have second thoughts. And those ideas are in tension. I mean, at what point does lawyers' set of values of making the system work and using the tools that the framers of the Constitution put in place have to yield to more contemporary concerns. It is quite a challenge. Let's talk about what kinds of things Congress has done or not done in this situation. I'll just start for 1 second about the history of military commissions. Military commissions probably, strictly speaking, date to the war with Mexico under the Polk administration. I'm sure viewers will remember that. And the commissions got their first expression in any act of Congress only indirectly during the Civil War, when Congress passed a bill to confer upon the Judge Advocate General of the Army the power to review military commissions. But there was nothing substantive about what was supposed to happen in a military commission. So it's like walking into a room backwards. Then you have legislation in 1916 that basically recognizes the existing state of play, namely there have been military commissions, most of them in the Civil War and Reconstruction era, and notably in the Indian Wars. The largest mass hanging occurred under President Lincoln in his second term in Soda Territory.
Though he did save the lives of a number of them.
He spared the lives of a number of them, although interesting, one of the Indians whose life he spared was in fact hanged anyway by mistake, and nobody found the proper way so far to really apologize for that. But in any event, so in 1916, Congress, before the U.S. is even in World War I, revises the Articles of War, the predecessor to our current military justice statute, to again acknowledge the existence of this institution and basically say very little else about it. Comes 1942, when the German saboteurs are caught. We have a trial that was held in secret in the Justice Department, in a conference room in the Justice Department. The Supreme Court blesses the proceedings in a very short opinion, with a very short judgment with opinion to follow, and the opinion is only handed down after those people who had been sentenced to death have been executed. Not considered the brightest chapter in the court's history. Then comes 1950, Congress passes the Uniform Code of Military Justice. We've had some additional military commissions in Europe and also in the Far East in the aftermath of World War II. But from 1951, when the Uniform Code of Military Justice takes effect, until 2001, when President Bush revives them, there is no history. It's a complete gap. It's like the 18-minute gap in the history of this legal institution. And what's happened during that period is the law of armed conflict has evolved tremendously, because the Geneva Conventions are negotiated in 1949. And, of course, in the 60s, you have the revolution in criminal law in this country, the constitutional revolution presided over by people like Chief Justice Warren, Justice Brennan, Black, Douglas, and so forth. So you've got on both levels, the international level and the domestic level, a target that is shifted, but you have an institution that is basically frozen in amber in the Polk administration, or let's say in Wilson's first term. So it's a very rickety backdrop. So with that by way of background, take us, whoever wants to take a stab at this, to 2006. The Supreme Court renders a decision. What happens then in Congress?
First, I want to make sure that someone pokes people in the audience if they've fallen asleep. Thank you for taking us back to Polk. There's one other bit of history.
This will be on the final, incidentally, and I'm saying that as a law professor.
So there's one other ancient bit that I think is important to notice, and that is there's a famous or infamous decision called Exparte McArdle right after the Civil War. So it's not about military commissions, but it's about whether Congress can grab away habeas jurisdiction.
Right, absolutely.
And in that case had been argued before the Supreme Court. And the Supreme Court Chief Justice was off because Johnson was being impeached at that point. So it's a charged moment in the history of the three branches of government. And the Supreme Court says, even though we've heard this argument, Congress has just taken away our jurisdiction, and that's okay. Once we don't have jurisdiction, we don't ask about their motive or anything else. so long as there's habeas somewhere, they seem to say. So it's a very murky opinion, actually, but a very important opinion about how powerful habeas is on the one hand and how much authority Congress has on the other.
Let me interrupt you in your run-up to the 2006 legislation. This semester I taught the military commissions as part of my military justice class, and of course one of the great cases you read is Exparte Milligan.
Right.
Landon Milligan was a Confederate sympathizer in Indiana, and he was prosecuted in Indiana, by the way, where the federal courts and the local courts never closed during the Civil War. He was prosecuted in the military commission on a theory that he and others were going to drum up a mutiny by Confederate POWs being held in the North. Mm-hmm. And it was taken seriously, but that's not the point I want to make. He obtained a favorable ruling from the Supreme Court of the United States, which stated that where the law courts are open, you can't have a military commission, basically, that the full panoply of due process applies. And that's what the case is widely understood about. Whether it's still good law, it depends on which subsequent precedents you look at. In teaching this, I did a little research this semester, and I found that after Milligan prevailed in the Supreme Court, he sued the people who were responsible for his military commission conviction, and he was represented, by the way, by an attorney named Benjamin Harrison. Yes, President Harrison, to be. And he won a jury verdict for $5. The federal judge who presided over this case gave a whale of an instruction to the members about all the factors they should take into account, which is the objective good faith of the officers who were involved in the military commission, the fact that we were in a civil war, and on and on and on. In retrospect, it's a miracle he even got the $5. Anyway, pardon the digression.
2006.
Right.
So this is what I was alluding to as the time when at least some of the members of Congress said they voted for it, but they weren't really sure what was in it. That happens a lot, unfortunately. It was interesting that they later were sort of apologizing for it when they realized what that act had done. Because what the Military Commission Act of 2006 did was to say these military commissions are okay, and if you're not an American citizen, there have been earlier cases by American citizens, you do not have access to a federal court for habeas corpus. So it was a sweeping undercutting of habeas corpus jurisdiction.
Now, that's not the first time Congress has done what's called court stripping.
Right.
Where
well,
has
McArdle
that? McArdle is the classic illustration. Right. Other illustrations also?
Yes, and there are also debates about if they do court stripping, are they faced with the precedent they don't like still being law, which can't be overruled. So that's sort of some of the fun we have in constitutional law. Right. But they also were willing to permit minimal procedures, shall we say, and they said the only place you can get this reviewed is in the D.C. Circuit, and only certain issues can come up for review.
Why the D.C. Circuit?
So that's what the Supreme Court struck down.
Why would Congress say you can only do this in the D.C. Circuit? That's not even close to Guantanamo.
Well, everything that's taken place, all the habeas cases, of course, are assigned to initially to the federal district court for the District of Columbia, and of course the D.C. appellate court then takes it from there.
And a lot of statutes refer things. Administrative law issues go to the D.C. Circuit, for example. So
forgive me for being cynical, though. I mean, would you agree with me that somebody might have harbored the nasty little thought that that was a friendly forum for the government?
That is possible.
Okay, back to your
so that's the statute that the Supreme Court, in the Kennedy opinion I alluded to, struck down.
Right.
And that's where Scalia said, but American lives are going to be almost certain to be lost.
Okay.
But interestingly enough, I think while that military commission statute was still the law of the land, I believe there were roughly 4 trials under that act. And speaking for my client, I sort of wish that he had been included, because what happened, the first one up, and I can't recall the name of the
Hicks
person.
was the Australian.
Hicks is the guy, the Australian. And so he was allowed to plea bargain. And as a matter of fact, as I remember, his charges were actually killing an American soldier or 2. And he was allowed to plead guilty with a plea agreement that he would be then sent to Australia to serve out the remainder of his sentence, which was like a year or a matter of months. And so he basically, for these intervening years, and that might have been roughly in '06 when that happened, he's been a free man during most of that time. And then we had the Hamden case, and then Mr.
He was the driver. He was Bin
the
Laden's driver.
Right, or one of
Right.
many of them. And in that case, the military commission exonerated him as far as the more serious charges, which included having a surface-to-air missile in the trunk of his car that he was transporting somewhere, and he was found guilty.
He thought he'd left it in the other car.
That must have been it.
It was in his wife's car.
Okay. But at any rate, he was convicted of some rather minor charges, and the sentence, and apparently this military commission was empowered not only to pronounce guilt or innocence, but also punishment. And the punishment was basically time served. And so he was sent back to Yemen, one of the few guys from Yemen that have been able to get back to their own country. And the last I heard about him through his attorney was that he was driving a taxi cab somewhere in Yemen.
What was the number of the cab?
Oh, you don't want to take that cab.
That's right. But you know, your comment raises a really, really important point. This is the recidivism point, the danger that people who are released, those who survive Colonel Gaddafi, let's say, you know, when they get home, are going to return to, quote, the battlefield, whatever that is in this context. So I'm sure you've seen these stories. What do you make of those stories? Are they claims that you credit, or do we not know enough, and can we ever know?
Well, they go all over the lot. I mean, the government, our government, has announced at times that there was they come out with numbers. Originally, there were as many as 800 different individuals who have been confined in Guantanamo at one time or another. I don't think all at once, but over the years it has reached that level. And obviously, to get down to 174, a huge bulk of people have been voluntarily released, not through the habeas process, but the government has just decided it was a mistake to have them there to begin with. And then on recidivism, you just see all kinds of numbers that flow from that. The ones that I have put the most stock in basically come from my fellow habeas attorneys, and it's a moderate number, like maybe 20 or so. And I think most of them are connected with Yemen. Mm-hmm. And I think that's one of the reasons that the present administration, even though among these people who are still confined, approximately 50% of them are from Yemen, and the majority of those have been cleared for release. But we don't want to send them back to Yemen out of concern that they would be induced to be terrorists.
Mm-hmm. There are people who believe we should have a special court for national security detentions. We already have one for foreign intelligence wiretapping, the FISA court.
They don't try people.
No, they don't try anybody, but they approve warrants.
Yes.
A very high percentage of approvals.
Basically all of them. Right. I mean, it's one or two where the I's haven't been dotted that are problematic. But do you favor a national security court?
Well, I would favor anything that would sort of get the show on the road. I mean, my client has been locked away in Guantanamo since August of 2002, and from March of 2002 he was at Bagram before he went to Guantanamo. Well, that's getting to be an awful lot of years. Mm-hmm. And I think at this stage it's in his interest that we have a determination as to whether he has done anything adverse to the United States, which is deserving of confinement, And if so, it's going to have to be something relatively minor, because my client has the unique experience of having his leg blown off by a landmine in 1998, and basically spent the next several years in and out of hospitals. He has a bad other leg, which has him confined to using a walker to get anywhere. And so to think of him as some kind of a military threat to the United States is just ridiculous.
Yeah, it's struck me that even though people who are not personally involved in this might have a different impression, there is a variety of views that people who are lawyers who are involved in these issues take. You are habeas counsel for a specific individual. Other people do not have individual clients, but maybe have institutional interests. I'm thinking now of some of the organizations that have become involved from a civil liberties perspective or a human rights perspective. And without asking you to divulge anything that's covered by the attorney-client privilege, but would it be fair to say that people don't necessarily see eye to eye on some of these larger issues, even though they're both, let's say, broadly speaking, on the same page in terms of resisting the government's programs for the detainees?
Well, possibly, but I can't say that I have any expertise in making that kind of judgment.
Right.
And I think most of the habeas attorneys are very directed towards their own clients and justice for those very people.
Right. Thinking about your own case, just 1 second, Avi. Thinking about your own client's case, you drew a judge who recently retired, this Judge Robertson in Washington.
And he was a senior judge.
Right.
Well before then.
And had been, let's say, at least as sympathetic to, as so far as one could tell, to the kind of submissions that were being made on behalf of the detainees. He took his role very seriously and was probably as easy a vote to get as there was on that court. So that would probably have been quite a disappointment to you, well, particularly given that judge. And of course, you don't have any choice in who the judge is going to be. That's a random selection.
As I recall, he basically was involved in decisions in 3 separate habeas cases. The first one, he refused to grant the writ. The second one, which was decided only a matter of months before our case came up for a hearing, was this Salahi case in which he ruled, and although Mr. Salahi, way back in the past, had been a member of Al-Qaeda, that he had relinquished that role a number of years before, and therefore was not at any relevant time a member of Al-Qaeda and hadn't really done anything to justify being locked away. And we basically used a lot of his decision in that case to apply to our case and thought we had a very good shot at getting our client released.
Did your client ever testify by television or other means?
No. He submitted a declaration, and he had a right, and the judge would have certainly allowed him to testify. However, we went down a week before his hearing, and he at that point in time basically announced that he had no faith in the American justice system and declined to participate, which was too bad.
And he's been confined for almost 9 years without charges.
Yes.
So one of the tensions or paradoxes is we believe strongly that guilt has to be individual, but we also use guilt by association a lot.
Well,
not only in these cases, but
right.
Particularly
in this case, especially so. The enunciated ground by Judge Robertson for denying our petition was that during this period of time that my client was being fit for a prosthesis and his wound from the leg loss was being tended to, he stayed between hospital stays at guest houses in Afghanistan. And my understanding is there are a huge number of guest houses that sort of take the place of hotels. There was evidence presented by the government that some of the guest houses he stayed in were owned or operated by Al-Qaeda or the Taliban. And he stated that this was the prime evidence that he was using to deny our petition. The idea that we stayed in these guest houses that were frequented by some of the big wheels and the Taliban, and that was enough. Mm-hmm. And there are many decisions now by the D.C. Circuit Court where that is a major criteria. If you've stayed in a guest house that is labeled dominated by Al-Qaeda, that's good enough to lock you away.
Mm-hmm. But there wasn't a sign saying that on the door when he stayed there.
Well,
so it's a retrospective labeling.
Yeah, I think so.
Let's talk about a case that doesn't involve a Guantanamo detainee and that doesn't involve a military commission. I'm thinking about the case of Mr. Geelani. He was prosecuted in federal district court in Manhattan on charges arising out of the bombing of U.S. embassy buildings in East Africa. Now, that case, and you may remember he was acquitted on all but one of the charges, and that case has become a lightning rod for anger because it demonstrates that the federal courts are incapable of prosecuting terrorists. Are they?
No, of course they can prosecute terrorists, and they have done.
Yeah, but losing all but one, and there were, I think, 275 or more counts in that indictment.
But the count that he was convicted of was conspiring to blow up the embassies. And as I understand it, he's right now awaiting sentencing. But for what he was convicted of, the sentence could be life imprisonment. We're sort of waiting now to see what's going to happen there.
And yet, drawing together some of the themes that we've talked about here, that case has been relied on by people who are trying to, people in Congress who are trying to prevent any of the Guantanamo detainees from being brought into the territorial limits of the country and prosecuted in federal district court because, by theory, this is an unsatisfactory outcome, and why take a risk?
But we've had convictions many times, many places, Oklahoma as well as Manhattan and so on. Federal courts are certainly imperfect, but they do a pretty good job of involving citizens if there's a right to jury trial, judges who have lifetime tenure, which makes a difference, and who are quite careful about such things as evidence.
You say life tenure makes a difference. Of course, military judges don't have life tenure. Why does it make a difference?
Well, I think, unfortunately, we just found out in Iowa what a difference it can make, where they don't really have a contested election for Supreme Court justices, but enough people got riled up, and most people were paying no attention, so that the three judges who had decided about same-sex marriage in Iowa were ousted, to the great shock of most of the people in Iowa, and certainly to a lot of people who believe in the independence of the rule of law.
And point being, not with respect to those judges who have lost their positions, but what happens with the next judge who is named to that court?
Exactly.
And is he or she going to
and
be
now
looking over their shoulder?
We're really in trouble, fortunately not in Hawaii, but in other places where there are contested elections and where millions of dollars are contributed, and judges are running for re-election all the time.
And just one more question. One of the arguments about not having trials in one of the regular federal courts was that it would cost a fortune. And security would be a major problem. Is that, there was a big hoo-hoo about that in New York City. Was that?
Well, it might have been an issue. I mean, right now you can't walk on the sidewalks in New York because there's gridlock, right? There's so many pedestrians. So it is difficult in Manhattan, particularly in the southern part of Manhattan, to get around and to get people in and out, given where the courthouse is located. But you could have a trial in North Dakota or near Leavenworth or something like that, and you probably wouldn't have those issues.
There'd be other issues.
Or you could have a trial with civilian jurors and so on at any of our military bases and have loads of security I mean, the public wouldn't be necessarily free to attend that way, but I think that any kind of solution that will allow my client a day in court is something
Better than-
that would be beneficial to him.
I have to say, just editorializing myself here, that
You have opinions.
well, one or two, only a few. But I'm very skeptical about getting fancy with the forum. I don't believe a civilian trial should be held on a military base. I didn't think there was a security problem in Manhattan. I think, if you remember, there was a suggestion at one point that it would cost $800 million to provide security for one of the high-value detainees that they were planning to try in Manhattan. And it turns out that when Geelani came on for trial, the New York Police Department, never skipped a beat, and the overtime was the same as it would have been. And there were, and by the way, you don't need a trial to turn New York City into a target for terrorists. God forbid anything more ever gets attempted there. But still, it's been there all along, and it's I guess, a tempting target to people who are cuckoo enough to harbor that kind of animus. One last point that I think maybe we ought to cover, and that is the sort of foreign implications of all this. We had the prosecution of Mr. Khader, who at the time of his apprehension in Afghanistan was underage. He's a Canadian citizen. And of course, his case goes on in the Canadian courts. He reached a deal at the last minute with the government, with the U.S. government, in a military commission, but he's got a lawsuit pending, or I think he's already collected some damages in Canada. I just think we ought to flag the fact that the pieces of this puzzle that we're seeing here play out, complicated enough, become even more complicated when you think about people in this increasingly globalized world, where it's not uncommon for people to have dual citizenship. Many of the people in Guantanamo now, or who are going to come across the screen in the future, are going to raise issues and be willing to raise issues in foreign court systems. We've seen that in Canada, we've seen that in the UK, we've seen that in Germany, and I believe in the French courts as well. So we're not even covering all of it when we talk about the kinds of issues that have gripped public attention here. Gentlemen, I'd like to thank you both on behalf of the management for this conversation and taking the time. And let me wish you and yours a wonderful holiday season. And I hope you both stay with it and keep on these issues. They're of interest to our country, and they're of interest to people here in Honolulu.
Thank you. I couldn't help noticing your last name is Fidell. Are you related to Jay Fidell by any chance?
Only by parentage.
Well, thank you.
Thank you.
Happy New Year to you.
Same to you.